All right, we ready to start?
Your Honor, before we begin, the prosecution has some pretrial matters we would like to discuss.
Okay.
First, we would like to make introductions. My name is Madeline Berzon, and I represent the state of Midland, along with my co-counsel, Josh Melton.
Good morning, Your Honor.
And Maylise Jensen. Good morning, Your Honor. We would like to ask your preference for us asking to approach opposing counsel, the witness stand, and the bench.
You're free to move around the well and approach whoever you want, aside from opposing witnesses. Always ask permission to approach witnesses that are not your own. As far as opposing counsel, the bench, and your own witnesses, free reign.
Your Honor, we also have 3 documents to tender to the bench. First, the indictment of Jordan Ryder for aggravated murder in the applicable penal code. Second, all relevant Midlands case law, and the Midlands rules of evidence as they differ slightly from federal rules.
Thank you.
And with that, Your Honor, the prosecution is ready to proceed to opening statements.
Anything from the defense?
Yes, Your Honor. First, we'd like to make appearances before the record.
Okay.
Your Honor, my name is Joshua Barrett, and I rise on behalf of the defense alongside my co-counsel, Ms. Amanda Adolph,
Good morning, Your Honor.
and Mr. Jordan Weeks.
Good morning, Your Honor.
And we represent the defendant, Jordan Ryder, in this case.
Good morning, Your Honor.
Next, I would like to tender to the bench a notice of intent to offer character evidence. May I approach and tender?
You may. Oh, first, has opposing counsel seen this document?
Yes,
Yes,
they
Your
have.
Honor.
Okay, you may.
It is signed. And with that, the defense is ready to proceed.
Okay. Opening argument from the prosecution.
Pushed to the edge. Parker Page was a loving, energetic 12-year-old girl. She dreamed of being a superhero and playing sports. She did all of this without the guidance of her mother, the defendant, who was absent for the majority of Parker's life. She was absent because she can't control her anger, ending up in prison, missing nearly 7 years of Parker's childhood. Parker was left to make the best of a broken life. When the defendant was finally released from prison, the reunion was joyful. But this quickly devolved into tension and anger. The defendant struggled with being the parent of a preteen girl whom she hadn't seen since the child was 5. This tension and anger culminated in a violent outburst, leading to a push. Just weeks after the defendant was released from prison, she impulsively took her daughter on a camping trip. The pair embarked on a hike known for its intense difficulty. The defendant wanted to push Parker past her limits, but Parker resisted. And like any preteen forced to do something they don't want to do, Parker got mad. But instead of being a patient parent, the defendant became forceful with her daughter. Parker kept complaining. She begged the defendant to stop. But the trail got harder, Parker's complaints got louder, and the defendant grew angrier, so much so she ripped the hiking staff out of Parker's hands and struck her with it, pushing her over the edge of a 40-foot cliff. As a result of the defendant's actions, the state is charging her with aggravated murder. There are 2 elements at issue today. First, causation. That the defendant's actions caused the death of Parker Page. Second, knowledge. This element means that we must prove the defendant knowingly caused the death of Parker Page. Keep in mind, this doesn't mean that we need to show the defendant's actions were premeditated. This element simply means that we must show the defendant knew her physical act, the push of Parker, would likely lead to her death. We will prove these elements beyond a reasonable doubt. First, you will hear from Mr. Kai Washington, the defendant's social worker, who is an expert in forensic social work. Mr. Washington treated the defendant for nearly 8 years. He is the only one who treated the defendant. Mr. Washington will explain the defendant's cycles of outbursts, treatment, and relapse. Mr. Washington will explain how in the days leading up to their camping trip, the defendant expressed aggression towards Parker, and how, when faced with resistance from Parker on the trail, the defendant was likely to respond with anger. Next, you will hear from Miss Dews, a hiker who saw the defendant and her daughter on the trail that day. She saw the pair arguing loudly. She saw the defendant grab the hiking staff out of Parker's hands, turn and strike towards her chest, pushing Parker back towards the edge of the cliff. Finally, you will hear from Dr. Quincy, the chief medical examiner who performed the autopsy on Parker Page's body. As Dr. Quincy will explain, this autopsy identified trauma to Parker's collarbone. Trauma that is an exact match in size and shape to the hiking staff used to push Parker over the edge. And as Dr. Quincy will explain, these injuries show it was the hiking staff wielded by the defendant that was used to push Parker over the edge. Throughout today's trial, you will hear how the defendant's temper was tested. But instead of controlling that anger, she pushed her daughter over the edge of a 40-foot cliff. Parker was pushed to her death by the person that was supposed to love her most. And at the end of today's trial, my co-counsel, Maylise Jensen, will explain to you how we have met our burden. She will ask that you find the defendant guilty. The defendant's anger was pushed to the edge. So she pushed Parker over the edge.
Thank you. Opening argument from the defense?
May I proceed?
You may.
Your Honor, opposing counsel, members of the jury, may it please the court. They have accusations, but they don't have answers. The state just came before you accusing Jordan Ryder of killing her own daughter. They threw out accusation after accusation, claiming that Miss Ryder pushed her daughter off of a cliff. But there's a few things that the state couldn't tell you. They couldn't tell you about one witness that actually saw this happen. They can't tell you about one witness that saw how or when Parker died. We have to ask ourselves, they can't give us answers to these simple questions, then why is Miss Ryder even being accused today? You'll hear today that Jordan Ryder, sitting right here today, was a loving mother. She cared about her daughter Parker more than anything in the world. So when Parker came up with the idea to go on a mother-daughter camping trip, of course, Miss Ryder was thrilled. She bought camping supplies, she set up a tent, and took her daughter to the Calkins campground, and even decided to go on a hike on the Lake Roan Loop. You'll hear today that they went on that hike, they came back together. And when they were at their campsite, everything was fine, or so Miss Ryder thought. And sometime in the night, Parker, she ran off. And once Miss Ryder realized she was gone, she searched everywhere to find her. But to no avail, the police found her first, and they found her body. Today, the state has brought forth a claim of aggravated murder against Jordan Ryder. This means that they believe Jordan Ryder killed her daughter and that she acted knowingly, and they have to prove the causation. First, knowingly. They have to prove that she was aware of her actions and that she was practically certain that pushing Parker off that cliff would have led to her dying. Secondly, causation. They have to prove that her pushing Parker off that cliff was She had to prove that pushing Parker off that cliff was a natural and foreseeable cause of what happened that day. And they have to prove all of this beyond a reasonable doubt. This brings us back to those 3 important questions. How Parker died, when Parker died, and if we can't answer those important questions, why is Miss Ryder even being accused? First, how Parker died. You'll hear today that even Miss Ryder herself doesn't know how Parker died. After the police went through a thorough investigation, they still couldn't tell Miss Ryder exactly how Parker died. You'll hear again from Miss Ryder that she can't say when Parker died. The police couldn't tell her that. You'll hear today from Dr. Lopez, a medical examiner. Dr. Lopez will come before you and tell you that even she can't say for sure when exactly Parker died. All she knows is that Parker most likely suffered severe respiratory issues on the day of July 14th. We can't say exactly when she died. You also hear from Cameron Lee, who was a hiker that was there at the Calkins campground. Mr. Lee is going to come before you and tell you that he saw Jordan and Parker come back from their hike together. The same hike that the state claims Parker was killed on. There's all this disagreement about how Parker died and when Parker died. We have to ask ourselves, why Jordan is being accused? And if we can't answer that question, we shouldn't even be here in court today. At the end of today's trial, my co-counsel, Jordan Weeks, will come before you, remind you that they have accusations, not answers, and ask that you find Jordan Ryder not guilty of aggravated murder. Thank you.
Thank you. Does prosecution have a witness?
Yes, Your Honor, the prosecution calls Mr. Kai Washington to the stand.
Point of order, Your Honor. Permission to move about the well if necessary to better see the demonstrative.
Yes.
Please introduce yourself to the jury.
My name is Kai Washington.
Mr. Washington, what do you do for a living?
I've been working as a licensed clinical social worker for the past 11 years, specializing as a forensic social worker and utilizing forensic psychology with convicted felons.
And what's your educational background?
Well, originally from Ireland, I received my Bachelor's of Business and Behavioural Management from University College Dublin. I then moved to New York City to work in a hedge fund there. But after about 5 years, I realised that wasn't the career route for me and went back to graduate school. I then received my Master's in Social Work with a focus on forensic psychology.
Can you explain to the jury what forensic psychology means?
Of course. Well, essentially, forensic psychology is using psychology within the criminal justice system. So I do this by working with adults who are in prison to help them be rehabilitated and be best fit for society upon release. And this is done by providing psychological, mental health and drug and alcohol evaluations, along with providing treatment to those in prison by counselling sessions who are suffering from behavioural disorders.
Is this how you're familiar with the defendant, Miss Jordan Ryder?
Yes, I worked with Miss Ryder between 2010 and 2018 as her one-on-one counsellor.
Do you see the defendant in the courtroom today?
Yes, she's sitting at the end of the counsel table here wearing a navy sweater.
May the record reflect that the witness has just correctly identified Miss Jordan Ryder.
It will so reflect.
Now, Mr. Washington, when did you first meet the defendant?
I first met Miss Ryder in 2010 after she pled guilty to a misdemeanor domestic violence charge against her half-sibling Corbin Dallas. As part of the plea deal, Miss Ryder had to complete 3 one-hour sessions along with a 4-week anger management program in the first 6 months of her release. I was assigned as her one-on-one counsellor.
Now, how long did that counseling go on?
That counselling went on for about 5 weeks. However, our more substantive work began in 2014 onwards.
Now, what was so important about this work that began in 2014?
Well, specifically, I was working on a 3-phase program aimed at reducing recidivism and ensuring full reintegration back into society for former inmates. Ms. Ryder became one of my first patients after she was involved in multiple prison fights within the prison itself.
Mr. Washington, are you here today to testify to an expert opinion regarding the defendant?
Yes, I'm here to provide my professional and expert opinion regarding Miss Ryder and the likelihood of her reacting violently in certain social circumstances.
And what principles and methods did you rely on to reach your conclusion?
Well, I had Miss Ryder perform an anger expression state and trait test, otherwise known as an anger expression test. This is used to assess whether or not an individual has been successfully rehabilitated whilst in prison. I then used the results of this test along with my own evaluations in order to arrive at my conclusions.
Did you reliably apply these principles and methods to the facts of today's case?
Yes, indeed I did.
And did you have sufficient facts or data to apply to your conclusion?
Absolutely.
Now, Mr. Washington, you mentioned that your treatment has 3 phases. Can you describe these phases to the jury?
Yeah.
Objection, Your Honor, is to an improper opinion. May I explain?
Sure.
I believe that 702C has not been satisfied yet. Although Mr. Kyle Washington has talked about the principles and methods that he used, if I may draw your attention to case law, Tarot Card Readers Association versus Merrill Dow. There are a few metrics that we can use to assess whether a principle is reliable, such as a known error rate or that it's well accepted in the field. And Mr. Washington has not testified today that any of those metrics have been met. And until those metrics can be met, I ask that the foundation be laid by opposing counsel.
Response.
Yes, Your Honor. Pursuant to Rule 702, we have laid the necessary foundation to establish Mr. Washington as an expert. We established his principles and methods. We established that they were reliable principles and methods, and we established that he used sufficient facts or data to reach these conclusions.
Okay, the second one that you named, what testimony had come out from this witness to establish that the principles and methods were reliable within this field?
I asked if he reliably applied the principles and methods that he testified are regular practices in his field, and he testified that he was able to reliably apply the information he gathered for this case.
So the extent of the testimony that's come out is he believes he has reliably applied these principles and methods based on his own subjective standard.
Well, through establishing that this has been his career for many years and establishing his background in the field, Mr. Washington testified that it is regular practice within his work to apply to this case.
Response.
Your Honor, I don't believe any statements by Mr. Washington have come out that this is a regular practice by a lot of people in his field. Although Mr. Washington said that himself he uses this method quite frequently, it still could be a bad method that Mr. Washington himself uses, and until any foundation is laid that other people use it, I ask that...
I'm inclined to agree with defense counsel, especially in light of the ruling in tarot card readers. If we could get with some level of specificity as to how he knows these methods are reliable within his field, I think that would be constructive.
Yes, Your Honor.
So sustained, and no opinions have come out yet, so I don't think there's anything to strike, but you can go.
Yes, Your Honor.
Mr. Washington, are the principles and methods you applied to this case regular practice in your field?
Right. Yes, so the usage of the anger expression test along with using evaluations based on counselling sessions is the gold standard for assessing behavioural disorders.
And have you ever testified in court as an expert regarding this issue before?
Yes, I've testified multiple times before regarding my expert opinion on forensic psychology regarding a former offender's behavioral analysis.
Now, Mr. Washington, you mentioned that that there are phases within your treatment program. What are these phases?
Well, I actually brought along a chart today to explain these phases.
Your Honor, may the witness step down to make use of the demo?
Witness may, and defense counsel can do what he needs to do to see everything.
Yes, Your Honor.
Mr. Washington, can you describe this chart to the jury?
Yes, so what we have here is the 3 phases of this program, and they're divided into rehabilitation, then re-entry, and then reintegration. So the ultimate goal of the entire program then is full reintegration back into society.
And when does phase 1 occur?
Phase 1 occurs whilst in prison, it's treatment whilst in prison.
And when does phase 2 occur?
Phase 2 then is a 6-week treatment course upon immediate release.
And when, lastly, does phase 3 occur?
Phase 3 then is a full successful reintegration course of long-term treatment, usually taking up to about 2 years, but quite frankly can take as long as it needs to post-release.
Can you describe what this leftmost column is to the jury?
Yes, of course. These were the primary behavioural characteristics that were addressed in Ms. Ryder's treatment.
Mr. Washington, did you work with the defendant on phase 1 of treatment?
Yes. So when I initially met Ms. Ryder, she showed signs of being hostile, irritative, and pathologically aggressive. So for these reasons, I diagnosed her with anger management disorder. And in my assessments, you can see on my pre-assessment pre-phases on the left-hand column here. So then in phase 1, I provide intermittent counselling sessions along with tracking her progress throughout phase 1 between 2014 and 2017.
How long did you work with the defendant on just phase 1?
Between 2014 and 2018. In 2017 then, I've been advising Ms. Ryder to enroll in anger management courses within the prison. However, for the first 3 years of the program, she refused to follow my advice. She finally enrolled in them in 2017. She then showed us marked improvement in her anger management control, and subsequently I performed a final evaluation on her in early 2018.
Can you explain what the results of this final phase 1 evaluation was?
Yes, so I had Ms. Ryder perform an anger expression test. This is the same test that she performed at the start of phase 1. In this test, I was able to analyse the progress that she had made in phase 1, and it displayed the results that she had a low likelihood of acting on her impulses whilst utilising the anger management techniques taught. Subsequently, I arrived at the conclusion that she met the threshold that she was rehabilitated for the purpose of phase 1 and recommended for her early release.
Did this mean that the defendant's anger management treatment was complete?
No, this just meant that she had completed phase 1. Treatment whilst in prison, whilst in the enclosed environment of a prison. She is then ready to begin phase 2, re-entry back into society. Phase 2 is crucial because it involves learning to deal with the disorder outside of the closed environment of prison, which if not managed correctly, could result in all progress being lost.
Did you work with the defendant post her release from prison for phase 2 of treatment?
Yes, so I worked with Ms. Ryder. I met with her 4 times between June 10th and July 12th, 2018.
And can you describe these post-release sessions to the jury?
Yes, so when Ms. Ryder was initially released, she was excited to be out of prison and reunited with her daughter Parker. She quickly began to realise then the difficulties of being a full-time parent again. She then, though, became frustrated and quite quickly with her daughter Parker. She said that she picked up some bad habits from her half-sibling Corbin Dallas, that she was disrespectful, that she would talk back, that she didn't push herself enough.
Was this information about Parker important in your analysis of the defendant's anger management?
Yes, indeed it was. Throughout Ms. Ryder's anger management history, family has been a major trigger. She wasn't able to control the family situation at home, or if it was causing her stress, she showed the possibility of maybe losing progress or potentially relapsing altogether.
Did you learn anything more about the defendant's control over her family issues?
Yes, so this was the central issue of our third meeting together in post-release. She confided in me that she was becoming more and more frustrated with her daughter Parker, that sometimes she just wanted to shake her. She made her that mad. Now this was a concern for me, and I discussed it further in that session and plan to discuss it further in future sessions as well.
Did you recommend the defendant to do anything to help control her anger?
Yes, so I gave her some general techniques in how to deal with Parker if she was being disrespectful or was upset. However, the main piece of advice I gave her was to avoid stressful situations with Parker altogether.
When was your last meeting with the defendant?
That would have been July 12th, shortly before Parker died.
So did the defendant ever finish phase 2 of her treatment?
No, that's why I have under phase 3 marked not available, or NA, she did not complete phase 2.
Now, after your counseling with the defendant, what was your assessment of the defendant after phase 2?
Well, given that Miss Ryder did not appear to be utilizing the anger management techniques that she'd been taught in phase 1 throughout phase 2, I can conclude...
Objection to a lack of foundation, may I explain?
Yeah, as to what specifically?
Mr. Washington just testified that Jordan Ryder did not use the specific anger management techniques that Kai Washington testified, and I just asked that the foundation be laid as to how Mr. Washington knows whether Ms. Ryder did in fact use those techniques.
Response.
Yes, Your Honor. Well, Mr. Washington was testifying based on the observations during these sessions post her release from prison. So based on the information that Mr. Washington collected from speaking with the defendant, these were his observations of her behavior.
Yeah, I mean, I think defense counsel is right in their objection, but I also think it's kind of pedantic. So to the extent that the witness testified that she did not, I'm just going to ask that it be rephrased to his knowledge, she did not.
Yes, Your Honor.
So sustained, but I think that's the way to cure the issue, and I would advise the witness to kind of limit those statements to your knowledge unless you have firsthand knowledge of some of the other things that you're testifying to.
Yes, Your Honor.
Yes, Your Honor. So once again, Mr. Washington, based on your observations and to your knowledge, what was your assessment of the defendant during phase 2?
My observations in phase 2 was that Miss Ryder was not following the anger management techniques that she'd been taught in phase 1. For that reason, I concluded that in July 2018, Miss Ryder posed a high likelihood of reacting violently if being provoked or agitated in stressful situations, particularly if those situations involved a family member.
Thank you. No further questions, Your Honor.
All right, cross-examination?
Yes, Your Honor. Would opposing counsel prefer me to deconstruct the demonstrative, or?
If you would like, I can deconstruct if you don't want to use it during cross-examination.
Yeah.
Okay.
May I proceed?
You may.
Good morning, Mr. Washington. My name is Jordan, and I'm going to be asking you a few questions on behalf of Ms. Ryder, okay?
Good morning.
I want to talk a little bit about your credentials. Now, you have a degree in social work, correct?
Master's in social work, yes.
And before you were a social worker, you did other work, correct?
I did indeed, yes.
And in fact, you quit that work specifically to become a social worker, correct?
Yes, so in my bachelor's degree I minored in behavioral management as well. I didn't find the business side of my career entirely exciting, but that's what I really wanted to focus on, was the social work side, yes.
You would consider yourself an expert in social work, right?
Yes.
So any conclusions that you come to in today's case are all based off of social work, correct?
Clinical social work is what I work on, specifically in forensic psychology. That's what I'm an expert in, yes.
You don't have a degree in forensic psychology, though, do you?
No, but in my master's, my thesis and dissertation was on forensic psychology. That's what my focus is in.
You don't have a PhD in psychology, correct?
No, I don't.
Yeah, you gave out psychological evaluations, correct?
Yes, that's part of my work.
I want to talk about a few interactions that you had with Ms. Ryder. So you first met Ms. Ryder in 2010, correct?
Yes, that's correct.
And Miss Ryder was on probation, right?
No, she wasn't at the time. That was just for a misdemeanor domestic violence charge.
And you would agree with me that you diagnosed with Miss Ryder with rage blackouts, right?
Yes, I did at the time.
And that's when she would lose control over her anger, correct?
Yes.
And like the name suggests, she would black out, right?
Yes.
She would become unaware of her actions, right?
Absolutely, yes. That's what a blackout is.
And if she got that angry, she didn't know what she was doing, correct?
That would be correct, yes.
I want to talk about the second interaction that you had with Miss Ryder. This was in 2014, correct?
Yes, our second form of treatment, yes, 2014.
This time Miss Ryder was in prison, right?
Yes, she was referred to me after being involved in prison fights.
Right. You saw on her record that she had a lot of prison fights, correct?
Yes,
She was instigating with other prisoners, right?
she was indeed.
And that's when you stepped in, correct?
Yes, well, she was referred to me, but yes, absolutely.
And you recommended Miss Ryder, actually, to take some anger management courses, correct?
I did indeed. Now, unfortunately, she refused that advice for 3 years, but eventually did enroll in 2017. And again, as I mentioned earlier, she did show a sparked improvement in her anger management then.
You told Miss Ryder that if she enrolled in the anger management program, you would give her a letter of recommendation to be released early, correct?
I said I would consider it. Nothing's given in prison in particular, but I said that if she showed a marked improvement and if she continued working hard, I would consider writing a good review for her.
And so she enrolled in the anger management program, correct?
In 2017, yes.
And she still had one-on-one counseling sessions with you, right?
Yes, indeed, yes.
And you taught her all sorts of treatments, correct? For her anger.
Yes, I tried to, yes.
And as far as your knowledge is, as far as you know, Miss Ryder didn't have any formal anger management before you, correct?
Yes, that's true.
And after you stepped in, you noticed considerable improvements, correct?
After I stepped in or after she enrolled in the anger management program?
After she enrolled in the anger management program, you noticed considerable improvements, right?
I did, yes.
She was no longer in prison fights, correct?
She wasn't, no.
As far as you're aware, she was using the techniques while she was in prison, correct?
Absolutely, yes.
And after you administered that test the second time, you saw a lot of improvements, right?
I did indeed, yes.
And after you saw those improvements, you yourself recommended Miss Ryder to be released from prison, correct?
I did indeed. I felt that she couldn't make any more progress whilst in prison, that if she stayed in prison any longer, given the amount of control over anger management that she had, she might start to deteriorate. That's why I recommended her for early release then.
You didn't think she was dangerous or anything, correct?
So long as she used the anger management techniques that she'd been taught, avoided stressful situations, and the fact that she was going home to a friendly family environment, I thought that she wouldn't be dangerous, no.
And if you believe she would have been dangerous, you wouldn't have given them the recommendation, correct?
No.
So after Miss Ryder was released from prison, you had a couple more one-on-one sessions with her, right?
Yes, I did.
And in those sessions, Miss Ryder did talk about Parker a little bit, correct?
She did. She confided in me that she was becoming frustrated with Parker, but yes, she did.
And at this point, you still didn't think Miss Ryder was dangerous, right?
No, I didn't.
And if you thought Miss Ryder was dangerous at this point, you would have gone to the police, right?
I would have, yes.
Miss Ryder told you, sometimes I just want to shake Parker, correct?
I did, and this was a concern for me, and that was at the start of our third session. So this session went on for nearly 3 hours. So at the start of the session, I felt as if we were actually losing progress of where we're at, that she wasn't utilising the anger management techniques taught. However, we worked hard throughout that session. I was able to assess whether or not she could apply those anger management techniques, and I thought she might be able to at the end of that session.
And still, after that, in your expert opinion, you didn't believe she was dangerous, correct?
No.
Because if you did think she was dangerous after those one-on-one sessions, you would have gone to the police, correct?
I would have, yes.
And in fact, it was you who recommended that Miss Ryder go to the Calkins campground, correct?
Oh, I did, but I recommended that as a stress-free zone, yes.
Now, I want to talk a little bit about your interactions with the police. Now, you communicated with the police after July 14th, correct?
After July 4th.
The police came to you, correct?
Yes, they did.
And you wrote up a report about Miss Ryder, right?
I didn't wrote a report? Or
An affidavit, correct?
Yes,
And the police asked you a couple of questions, right?
they did indeed.
And out of all those questions, they didn't mention Sam Fisher one time, isn't that right?
No, that name doesn't ring a bell.
They didn't mention the name Sam Fisher or ask anything about Sam Fisher to you, correct?
No, they did not.
Thank you. At this time, I have no further questions, Your Honor.
Thank you. Any redirect?
No redirect, Your Honor. I just ask that the witness be allowed to step down.
You're excused, Dr. The prosecution have another witness.
Yes, Your Honor. The prosecution calls Kelly Deuce to the stand. Good morning.
Good
Please-
morning.
Please introduce yourself to the jury.
My name is Kelly Dews.
Ms. Deuce, what do you do for a living?
So I call myself a professional thrill seeker. It's kind of like an influencer, but instead of selling people oversized, overpriced makeup or bogus supplement pills, I make videos where I jump off buildings and go on wild adventures all around the world. I love doing anything that brings me closer to nature. You could say I'm like a younger, cooler Bear Grylls.
Have your adventures ever brought you to Midlands?
They have. I went for the first time last July, but I don't think I'll be going back anytime soon. I was at Calkins Campground in Midlands when that girl Parker Page died.
Why were you at Calkins that weekend?
Well, I was actually working on my new book. Working title, maybe she's born with it, maybe it's Maple Leaves, an anthology of hiking, thrill-seeking, and finding inner truth in the outdoors. I had heard that there were some supposedly haunted trails in Midlands that would make for some good book content.
Had you ever been to Calkins Campground before?
I am not.
How did you know which trails to hike?
Well, I'd heard that the Leckrone Loop was the trail to be on, so I grabbed a map and started to find it.
Would you recognize a copy of this map if I showed it to you today?
Absolutely, yeah.
I am approaching opposing counsel with what has been marked as Exhibit